But the party convicted.
Professor Ray, on this, I'd like to stress the Constitution was written more than 200 years ago, and it's still effective as law in this country. It's amazing that they had the forethought to write a document that effectively is working even today.
This is an extraordinary document prepared by extraordinary individuals who, as we have been told by great justices of the Supreme Court, they were writing a document for all time. And it is well for us to remember that we are one of perhaps the oldest living republic in the nation having a written constitution. And so the document is extraordinary, and that's why its specific language is important. And it says, but the party convicted shall nevertheless be liable and subject to indictment, trial, and judgment and punishment according to law. So we have to remember that the question is, should we remove this individual? This is a removal provision. It really doesn't deal with punishment. So there are other provisions that have been mentioned.
Judge Ray, one of the things that I find is in the Constitution, it doesn't say that it's a criminal trial. It allows just for removal, and I think that's something that also is significant, because even now we hear about the Starr Commission, or basically Mr. Starr considering bringing charges which are very different from the impeachment process.
Yes, the impeachment process is a removal provision, and the president may thereafter be tried for whatever crimes he might or might not, or he might have committed. The important point is that it is true that the words are not defined, but we know what was intended. It had to be a gross breach of trust. It had to be a serious abuse of power. And the difficulty is, do the acts, do the facts as we know them rise to the level of this serious matter, such as what were called at common law the high crimes and misdemeanors, referring to the great offenses. They always involved gross breach of trust, serious abuse of power. Now, this doesn't diminish the wrongfulness of conduct, but the question is it
something that
that is that serious?
Right.
Now, of course, we often say, well, it's been put in the hands of the Congress because they are to reflect the popular will, and therefore each member of Congress, in the case of the impeachment, each member of Congress in the case of the Senate, must look to its constituencies. Of course, they will look to the constituents, but the fact is that the Constitution doesn't provide for a popular referendum.
No.
If that's what they wanted, they would have said, and the people shall determine whether he shall be retained in office or something to that effect. They simply said that the sole power for that trial shall be in the Senate. And by the way, those words are very important for another reason. An individual who feels aggrieved cannot then do what so many of us very proudly do. We resort to the courts. The courts have said, in many opinions by our Chief Justice, who has spoken with incredible clarity on the subject, those questions are not justiciable.
And that means?
That means you cannot bring them to the courts. And the actual language of the opinion in several specific cases brought by judges who didn't like the fact that they were found guilty by the Senate, not by the whole Senate that heard the case, but by a committee. The Senate, for example, has enacted its own rules in order to carry out this responsibility. They started in 1868, I believe, and I think it has maybe 26 or so rules that it has enacted to carry out the responsibility. Rule 11 says, and it's been used in relation to the judges, that they will have a committee look into the matter. Then the committee of the Senate makes a presentation as to the full Senate. And one judge was actually tried and found guilty and removed from office pursuant to the procedure set forth in Rule 11, and he sued in the courts. And Justice Rehnquist in the Supreme Court said this is solely within the power of the Senate. The Constitution says so, and that means it's not a judicial question. It's not a justiciable question.
Now, there are some questions related to what's going to happen in the Senate as far as the impeachment process. One of the issues is many senators feel that they'd like to say that our president has done things that aren't appropriate but not impeach. Can someone, and again, there are no rules, this has happened so infrequently in the history of our country that the Senate can basically draft their own rules, and there may not be any process to review what they do related to impeachment.
What will be done by the Senate will be final. It has the sole power to try and decide whether or not it will convict. There's no question of whether it will impeach. You hear that occasionally. In the particular case, the incumbent has been impeached by the House. The question is, what will the Senate do? Will the Senate convict? It is upon conviction, and it must be remembered that if there's a conviction of even one of the articles, the individual, if found guilty, will or shall be removed. Now, there is this additional clause about disqualification from future office. As we've applied that, we have sometimes removed and not added that, sometimes we have. It's interesting to note that in the particular articles of impeachment, after each article, the House articles of impeachment that were forwarded to the Senate and now before the Senate for trial, they specifically state, wherefore the name of the incumbent by such conduct warrants impeachment and trial and removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So you see the body that had the responsibility of determining whether we shall have this precondition to trial. I presume that if I wanted to be professorial, I would say that I'm not going to use words such as indictment or anything else because that throws me into another body of law. This is unique, as I said, sui generis. This is the precondition for trial, that responsibility. It's awesome because the Senate finds itself, and how can I not remember the many, many courts martial on which I sat, where I was law officer. And how well do I remember under the old Articles of War, the manual for courts martial that some of us members of the Judge Advocate General's Department practically memorized. The court there had to determine, did this individual commit this offense? I remember in murder or rape, for example, under the old Article of War, if found guilty, the punishment was set forth in the actual article that said, the penalty shall be death or imprisonment for life. And you occasionally found the court struggling. We didn't want to impose that punishment. What do we do?
Well, that's one of the issues. What do you do when...
Well, once in a while, what might have happened under that law that really left no choice to the trier of the facts, that they would do what? They would acquit. Very wisely, Congress in 1950, I think it was the Act of May 5th, 1950, and now under the new article, under the new manual for courts martial, the punishment under the new article for rape, for example, is that the punishment may be death or such punishment as a court martial may direct. So you could say 20 years, 30, whatever they want.
Yeah,
so that is why I don't like to use the concept of the jury, where you might have a real nullification of the charge that the judge may give the jury.
And a nullification is where the jury doesn't listen to or believes the law is too harsh.
Or believes that something is wrong and that this individual simply shouldn't be punished, And it will do what? That's why we occasionally refer to it as an instrument of freedom at the hands of a tyrant, you see. So that's why it's difficult to use analogies. Now, to go back to our subject, good behavior is not defined. High crimes are misdemeanors, but we know that they have to be serious because they're placed in juxtaposition to the words treason, bribery.
That was another issue because the allegations against our president, evidently other presidents have been in similar circumstances but have not been exposed.
Well, I don't know about that. That I don't. That's a. I don't know about that. Well, the question of fact. You may say, well, the question of fact as to whether it is sufficiently impeachable has already been determined. Well, I don't know about that. It's still solely within the power of the Senate to try. The Senate may conclude that the acts charged were not committed. That's casting no aspersion upon those who said that we believe that it should proceed to trial.
But the issue of whether it's a high crime, and it says and misdemeanor, because I think misdemeanor today may have a very different meaning than it had in the past. If you jaywalk, that's a misdemeanor.
Well, let's put it this way. I would hope that jaywalking is not a misdemeanor, but let us assume that a particular state made jaywalking or some other minor offense a crime. That would not necessarily be the kind of crime intended because it doesn't rise to the seriousness required by such a difficult and draconian, shall I say, situations where the punishment is removal from office. So it need not be necessarily a crime. It may be something very, very serious and yet not be a crime. It may be a crime and yet not be very, very serious because you can show that perjury may be deemed more serious than perhaps bribery, you see.
Although there have been times when a president or a high official is, well, it's very difficult for them to express their position because it may endanger other people. Examples might be during a time of war. It might be where there are confidences, where the president can't admit to things. And I think these are issues, that maybe haven't been addressed.
Well, the only examples that we have really are in the presidential area. We only have the impeachment of one president who was not found guilty by the Senate by one vote in the case of Andrew Johnson, and there we do not have a case of a president who was removed from office pursuant to the impeachment process.
I think in one of your articles you mentioned that President Andrew Johnson was impeached on a law that was later found to be unconstitutional.
Yes, that was a case where, frankly, it wasn't a situation where perhaps he should have been impeached. They passed a special law, which was a law on tenure for public officials, and they said that he violated it, and interestingly enough, years later, the Supreme Court declared that very law that the president was charged with violating as having been unconstitutional. That's true. So there, by virtue of the 2/3 provision of the Constitution, President Andrew Johnson was not found guilty of impeachment. The situation that also arises is, what does the Constitution say on censure? That's often asked. Well,